Can I scoop you out?
Yeah.
Right.
Have you talked to your client lately? The last one said they hadn't talked to you for 4 months before the trial, but that's a problem. Two of them said they hadn't talked to you for 4 months.
I've talked to her, not recently.
When? I mean, aren't,
This, you know,
where's Sarah Saminsky?
first person here.
I'll be.
This involves the death of the child. That's the injury is death.
Okay.
State is ready.
All right. Okay. And y'all are ready? All right. Y'all been talking with her? You've been working with him? When was the last time you spoke with him? A month ago, and we're in trial today. My God.
I've been trying to get a hold of his office, and it like says I get the phone number is different. And I also tried to message him, and then I'm going through and
It's a trial today. Yeah, but y'all haven't also, all right, y'all, I mean, you know, we can go to trial right now and we're ready.
and only Fridays from 1 to 4, and I've tried to call and I haven't got anything.
That's
Yes, I did. I was like, not this.
It's the day for trial, you know, you got to strategize and prepare and, you know, rehearse your testimony. You didn't even know you're going to be under trial.
I didn't get anything from him. I didn't get any letter or any phone call.
All right. I'm sorry.
I didn't get anything from my.
That's not. Yeah.
But that's how I had gotten a hold of you in the shots. That's how I've always gotten a hold of you.
She was texting him Facebook Messenger.
I don't know. You know what I'm going to, you know what I would say. I've done this for 40 years and I've never come to a trial without being prepared with a meeting.
I'm ready to try. I'm not.
She hadn't talked.
No one told me anything about the trial.
She says she's surprised there's even a trial today.
The boss was responsible.
Not. You're not? Her lawyer is not?
I do my best.
What have you done? Oh, not, okay. All right. Well, I've never heard, this is completely, I've done this for 45 years and I've never heard of such, I've never heard of this.
I didn't hear until
Really.
today.
And then the last, what they said last week when you weren't here at trial docket. So we had a trial docket, you didn't even show up.
I was in the trial and.
Sir, you interrupted me just then. Sir, you interrupted me when I was speaking to you. Sir, I'm speaking to you. I didn't finish my sentence, if you'd be so kind. We had a trial docket. You never showed up for the trial docket, and the people there said they hadn't talked to you in 4 months. And it was obvious y'all weren't going to be able to go to trial. We had to go to trial on another case.
Notice order from Judge.
Sir,
Because
sir,
it was in trial.
Sir, once again, those are things you need to speak to me directly for, because the protective orders, look, we know what's going on with protective orders. And this court has a fair opportunity to be heard on its protective orders.
It wasn't a protective order.
Well,
I did pick a jury.
This court generally doesn't do that, but I know some courts do, but I'm supposed to find out way ahead of them. I should know way ahead of a trial when that's being pulled, because the courts have a fair opportunity to be heard, especially ones that don't do the protective orders like I do. I know what goes on, and in some of the counties, you know, it's subject to abuse, and that's not fair to the people who are the 22nd largest county with the 16th highest crime rate, like ours. I think we have some prioritization for the people of Jefferson County. You can't go to trial right now. You know, y'all aren't ready for this.
Trial, but we didn't know when, and that's the first thing I heard.
Okay, well, there's got to be preparation, and you just can't impromptu come up here and start testifying. You know, it has to get rehearsed and things like that. Y'all just be silly, please. Y'all can be sued. Yes, you can be sued.
Just.
All right. Oh, I thought, I didn't be in the bar.
The device was placed on him, it was October of last year, it's been 14 months. In those 14 months, there have been no violations of any kind, there's been no contact with the complainant. In fact, they haven't seen each other in over 10 years since the divorce in 2015. My client doesn't even know where she lives. There have been no prior offenses involving any kind of violence whatsoever in his history. And also there's the cost of the device, which is taking its toll on my client since these charges caused him to lose his prior job, and he's had difficulty making ends meet since then. But he is doing it, but just the cost of the device, it's taking its toll. And I believe mitigating all of these the device being placed on him, all these factors that I just told to the court, Your Honor. He's here, he's come to all of the court settings. He has no intentions of making any kind of contact with the complainant, especially since these charges were placed on him. And we would ask the court to consider removing the device placed on these factors.
Your Honor, given the nature of these charges, and speaking with the victim in this case, we do believe that there is a risk of contact. I think that this is a safeguard against that. He knows that he's being monitored right now, so he hasn't had any contact, and we would like to continue to prevent contact until this case can be resolved once and for all. So we'd ask that it remain on.
Not to answer that, I would just offer that I don't think the defendant is going to risk the consequences of such contact, given the defendant's familiarity with this court and the possible consequences that would ensue if any contact should be made. I think the court can rest assured that the complainant need not worry about any contact being made by the defendant.
Well, I'm looking at this probable cause affidavit, and it's disturbing to say the least.
I understand.
Each act was a crime. Each act is a crime. They only indicted me once for one. But each act is a crime of what I'm reading about, these threats. And does the defendant have a criminal history at all? Any at all?
He does, Your Honor, but they're from, none of them are any offenses involving violence, and the ones that he does have are like from 20 years ago.
I don't believe there's any felony history, Your Honor.
Okay.
Doesn't care.
All right. These, I'm looking at one set of messages here on January 3rd.
Yeah,
Let me just, it's not a debate. I'm reading this and it's what it is. There was, these are very, you would have to agree, these are most disturbing. Disturbing. Okay.
yes, sir.
Okay. All right. If they were true.
There is a
There's
presumption of it.
voice. There's, y'all have voicemails on this? Recorders voicemails? There, it says, sent 2 emails with 2 voicemails. And the first voicemail said one thing, and I mean, these were, then the officers received additional emails from the complainant with screenshots of missed calls and a text that was sent to the complainant's son, which was a picture of an insurance policy. Do you have that?
Yes, we have that.
Okay. Okay. All right. And these emails, screenshots And, Officer Avery received an email from the son of the complainant that he received nude photo of his mother via text message for the second time. I mean, this was a period of time where heck was occurring. This was very threatening and intimidating. It hasn't occurred since.
To my knowledge, no, Your Honor,
I
but
think it's because of what she came forward and had the courage to make a complaint, and that the conditions of bond that were set or freezing this action. But this is not just one isolated event. This was several things that happened.
That are alleged to have happened, Your Honor, and I would say
Either the message is, come on, y'all have text messages?
but Your Honor, the text message.
I'm sorry. Y'all have text messages?
yes, we have all of the evidence that we got from the police department.
All right. So you're saying those are contrived and made up?
No, I'm just saying there's.
You're nodding and he's saying no. Y'all need to get on the same page. Here's what we're gonna do. The condition of bond continues. We're freezing this and this situation until we can get this thing to trial. But I've done this so long, I know what happens. Passion plays in.
This is the turning point. The judge has heard both sides, and now every word matters. Watch carefully, because his final reasoning is about to decide what happens next.
In all romantic interest, there's passion in it, and it makes people, it can cause people to act sometimes in a way that's unreasonable to what they normally act like. But what we're going to do is shame on somebody. The first time, shame on me. The second time, on my watch, if I let the guard down. Right now, there's nothing bad happening that I'm aware of.
That's correct.
So we're going to continue the status quo until we can get this thing disposed of and try to get it as fast as I can. I've tried 600 jury trials. I'm going to brag about it because I don't understand. 600, and that doesn't stop people from asking for trials here. You would think people would say, "Oh, he's going to try this case." We all know 98% get disposed of without a trial. For some reason, 98% go to trial here, and I can only try one at a time. But when you find a judge that's tried 600, let me know. Felony trials, let me know, because this doesn't happen. We're working one at a time, as hard as we can. And one of the reasons we don't have additional problems while on bond is the court's bond is firm about the bonds. And he's going to have to kind of bear with this a little longer until we can get this disposed of. But nothing bad is happening according to the state. And the court feels like the bond condition on his device is and it is, in not in his case, but in almost all cases, stops issues and keeps the status quo from changing for the worse while we're waiting. And that's, I appreciate your vigorous representation of him, but this is in the best interest of all concerned. And that's my best point. What are we going to do on this?
The state is ready for trial. We were ready today, Your Honor. It's just a matter of getting it on a trial docket and reaching it.
Get it to trial as soon as we can.
Yes, you
All you can do. So
Thank you.
get it resetting.
And just like that, the hearing comes to an end. The judge makes it clear that keeping everyone protected takes priority until the case reaches trial. Justice doesn't always move quickly, but today's hearing showed why preparation and caution can make all the difference. Let us know below if you think the judge made the right call.